order of 19th of November 2021, this court appointed the second respondent, herein after Rao, as the administrator of Mumias Sugar Company, Limited Mumias. It directed that he was to double as the receiver thereof, a position he had been holding since September 2019. It was the court's belief that the saga surrounding Mumias would have finally come to an end after proving Rao as both its receiver and administrator, and endorsing him with the duties and responsibilities of an administrator under the Insolvency Act. He was to ensure that the objectives of administration under the Act were met. However, barely a month after his appointment, the circus was back in court, more vicious than ever before. 6 applications were filed seeking various players. These applications are as follows. A. The motion dated the 3rd of January 2022 by Mumias Sugar Company. B. The motion dated the 28th of January 2022 by Vartex. C. Motion dated 31st of January 2022 by Kereto and Associates, the petition. D. The motion dated the 10th of February 2022 by 5 former employees of Mumias. E. Motion dated the 10th of February 2022 by Camino and Camino Advocates and West and Senior Advocates. F. The summons dated the 4th of March 2022 by Vartex. The court has carefully considered the 6 applications as analyzed above. All the affidavits and extras, oral and written submissions of record, and the issues that fall for determinations which emanate from the said applications are 7 in number as follows. Whether forensic audit should be carried out on Rao's receivership accounts as submitted in his affidavit dated the 18th of January 2022. 2. Whether Vartex Resources Inc. should be joined as a creditor party to these proceedings. 3. Whether Rao and the CEO of KCB should be summoned for cross-examination. 4. Whether the court should revoke the appointment of Havin Ladoke as the receiver manager of the cogeneration and ethanol plants of Mumias. 5. Whether the 5 former employees of Mumias have locus to bring the application to the 10th of February 2022. 6. Whether the court should revisit the locus in clause 7. Whether the lease agreement relating to the assets of Mumias given to Sarai Group Limited by Rao should be cancelled and revoked. And finally, 8. Whether Mr. Rao should be removed as court-appointed administrator and receiver manager of the company. Analysis. On issue number 1, whether forensic audit should be carried out on Rao's receivership accounts. The petitioner prayed for a forensic audit of Rao's receivership accounts dated the 29th of June 2020, 10th November 2020, and 12th November 2021, filed in court on the 18th of January 2022. The basic was that Rao filed the aforementioned receivership accounts detailing revenue receipts of 1.4 billion, which was enough to pay off the first respondent's debt with the company. On his part, Rao contended that the prayer for forensic audit of the accounts lacked merit, as the accounts were self-explanatory and showed no surplus as suggested by the petitioner. Further, that he had to procure overdraft facilities from KCB as the appointing creditor to enable him to undertake rehabilitation, repairs, and meet the expenses of the need. The beginning point is the ruling of this court of 19th of November 2021. Paragraph 134b1 thereof directed Rao to file with the court a detailed statement of account of all payments and receipts arising from the receivership of the company from the date of appointment yet. Full stop. Pursuant to that order, Rao annexed the statements at pages 1 to 3 of the exhibit marked PVR1 in his affidavit on 18th of January 2022. The court has considered the said statements. The opinion the court forms is that the said accounts present a detailed description of the payments and receipts from September 2019 until September 2021 as required by the court in its ruling. All that the court wanted was a disclosure of what had been received and how it had been spent. Whether the expenses were lawful or warranted, that is a different issue altogether. In this regard, I find no basis for ordering a forensic audit. Issue number 2, whether Vartox Resources Inc. should be joined as a creditor or party in these proceedings. Vartox's case was that it was a secured creditor of Mumias, in whose favor and benefit the plans were secured. This was by virtue of debt owed by Mumias to EcoBank, who assigned the debt to Victoria Commercial Bank, VCB, and VCB later assigned the same to it. It produced a notice of assignment addressed to Rao as evidence of that contention, that the two assets were excluded from the security treated in favor of KCB and other lenders as per the interlenders agreement dated the 22nd of September 2010. That this fact had been acknowledged by Rao in his letter of 22nd of December 2021 over the assets of Mumias to the Sarai group, which excluded the joint assets. The application was strenuously opposed on the ground that there was no satisfactory evidence that Vartox was a creditor. Further, that no orders could be granted to Vartox as it was not yet a party. In the case of East African Cables PLC versus EcoBank, the court held, generally, joiner should be permitted if all parties in whom any right to relief is in respect of or arising out of the same act or transaction or series of acts or transactions is alleged to exist, whether jointly, severally, or in the alternative, where if such persons brought separate suits, any common question of law or fact would arise. The court is generally guided by the principle that all parties necessary for the effective determination of a dispute should be joined to the proceedings. In the present case, the record shows that the two assets claimed by Vartox were not the subject of the lending by KCB. Vartox claims that they were charged to different lenders who had assigned the same to it. Those are mere allegations. The point of proving the debt is not at this stage now, but at the appropriate stage of this insolvency proceedings. In this regard, since Vartox alleges to be in the shoes of the alleged lenders, it may have a right to relief in respect of the administration of Mumias. It is undeniable that the direction that Mumias takes affects all the assets of Mumias. This will affect the rights of everyone who claims a right to be enjoined in this proceeding to prove its claim. In this regard, should Vartox bring another separate suit, common questions of law and fact will arise regarding the debts owed by Mumias. Hence, it is only reasonable that it should be enjoined in these proceedings. In this regard, prayer number 2 of the application dated the 28th of January 2022 is merited and is hereby allowed. Issue 3, whether Rao and the CEO of KCB should be summoned for examination. The subject application was brought under Order 19, Subgroup 2 of the Civil Procedure Rules. I have set out the rule. In SMT Sud and another versus Manmohan and others, the court held, the order for attendance of a deponent of the affidavit for cross-examination is in absolute discretion of the courts. It is true that absolute discretion means not arbitrary, but judicious discretion, giving justice-oriented approach in summoning the deponent of an affidavit for cross-examination. Order for attendance of the deponent for cross-examination would not be ordinarily made unless the court is satisfied and convinced that the application for summoning the deponent for cross-examination is necessary in the interest of justice. Unless both the conditions coexist, the courts have no jurisdiction to summon a deponent for cross-examination. In his submissions, Mr. Esmail, learned counsel for Vartox, accused Rao of dishonesty. That in 004 of 2022, in HCC E 004 of 2022, Lambert Ruanga Ogochi and 4 others versus Ponangipali Rao and others, Rao had challenged the jurisdiction of that court. Yet in this proceeding, he wants the parties heard in that other case that he should be cross-examined on the accounts which he had filed. That some of the expenses were suspicious, including donations and facilitation, which he had not explained. that there was no proper explanation on how the lease was executed on the 22nd of December 2021. In response, Rao and KCB filed a preliminary objection dated the 7th of March 2022, which the court has considered. The court has carefully considered the wording of prayer numbers 2, 3, 4, 5 of the application by Vartox. It seeks to cross-examine Rao on a total of 7 affidavits. It did not set out with specificity the paragraphs in the subject affidavits that it wished to have Rao and the CEO of KCB cross-examined on. It should be noted that the jurisdiction of cross-examination under Order 19 of the Civil Procedure Rules, although discretionary, is restricted. It is not meant to allow or order a full-blown trial. It is meant to only discredit the depositions made by a deponent in an impugned affidavit. It should not be too general as to risk a full-blown trial at an introductory stage. In the present case, the court is able to discern the effect of the depositions by Rao without necessarily having him be cross-examined. Accordingly, the court finds that there was no basis that was laid for the summoning of the deponents of the subject affidavits for cross-examination. Those prayers are dismissed. 4. Whether the court should revoke the appointment of Javier Taloke as the receiver manager of the co-generation and development plans of Mumias. The affidavit in support of this application was sworn on 6 January 2022 by George Kashindi, counsel for Mumias. It was contended that Mumias was placed under administration on the 19th of November 2021 to run concurrently with the receivership. Therefore, the appointment of Taloke on the 29th of November 2021 by VCB was void as the consent of the administrator or the approval of the court was not obtained. That it is sought to remove the 2 assets from administration. The application was opposed to the ground that it was filed against VCB, which was no longer a party, that the appointment was not in breach of Section 560 of the Act, and that the ruling of 19th of November 2021 had allowed the enforcement of the towards securities. Section 560, subsection 1A of the Act provides, while a company is under administration, a person may take steps to enforce a security over the company's property only with the consent of the administrator or with the approval of the court. It is clear from that provision that any step in enforcing a security against the company and administration must be consented to by the administrator or be sanctioned by the court. The objective is to prevent the possibility of multiple centers of realization of the assets of the company, which might lead to its dismemberment. Indeed, this is so even on the filing of proceedings against such a company. See the Court of Appeal decision in Akumat Holdings vs. ID Locations. In the present case, it is not in dispute that by the time the doctor was being appointed on the 29th of November 2021 as receiver manager, Mumias had already been placed under administration. No doubt, his appointment as receiver was a step in enforcing an alleged security. The consent of Rao or the approval of the court was necessary before such appointment. The court concurs with the submissions of Mrs. Kashindi that the appointment was an attempt to remove the 2 assets from administration. The appointment was contracted. That will do. Accordingly, there is merit in the application dated the 3rd of January 2022. The appointment of Gadzoke as the receiver of the company in respect of the plans is void and cannot stand. The respondents in that application and all their agents and or assigns are restrained from interfering with the plans in any manner whatsoever without the approval of the court or the consent of the administrator. The application is therefore allowed as print. Issue number 5. Whether the 5 former employees have broadcast to bring the application dated the 10th of February 2022. The first and second respondents contended that the 5 former employees lacked the capacity to bring the application since their grievances related to issues that Mr. Rao had discussed with the workers' union. That the said employees had not demonstrated that they had been authorized by the union to lodge the application. On their part, the said employees maintained that they joined these proceedings in their capacity as creditors of the company and not as representatives of the union. It was their contention that their constitutional right to seek legal redress before this court cannot be curtailed by the mere fact that they belong to the workers' union. It is important to note that the application by the former employees was brought under Section 591 of the Insolvency Act. The said provision allows a creditor or a member of a company under administration to apply to court to challenge the administrator's conduct of the administration. In insolvency proceedings such as the present case, employees or former employees who are entitled to salary arrears and other employment dues are considered as unsecured creditors. For that reason alone, this court's view is that being creditors of the company, the 5 former employees have the locus to challenge Rao's conduct of the administration. This is so particularly in view of the fact that nothing was presented to this court to show that they were expressly barred from agitating the individual interests without the authority of the union. Accordingly, the 5 former employees of Mumias had properly presented their subject application for consideration by this court. Issue number 6, whether the court should conduct a site visit. The creditors urged the court to visit the locus in court, claiming that they had information from credible sources that Rao and Sarai group were cannibalizing the assets of Mumias despite the court orders being released. The creditors submitted that without a site visit, the court will not be in a position to fully appreciate Mumias' asset base in order to make a determination of whether a monthly rent of Kenya shillings 19.5 million is commensurate with the assets. Further, they contended that a site visit will unravel whether indeed there is no activity going on in the company's premises as opposed to by KCB and Rao, while the statement of receipts and payments filed in court on the 18th of January 2022 shows clearly that income and expenses were arising from various activities there. We further contended that a site visit will clarify why Rao handed over Mumias assets to Sarai Group immediately after execution of the lease, allegedly for purposes of repairs, yet he claims to have undertaken various repairs in readiness for resumption of the company's operations. On the other hand, Rao and KCB submitted that the allegation of cannibalization of the assets of Mumias was vague, baseless, and unsubstantiated. Under Order 19, Rule 3.1 of the Civil Procedure Rules, amendments in an affidavit should be confined to facts in the deponent's knowledge. In their view, therefore, no basis has been laid for a site visit. Site visits is provided for under Order 18, Rule 11 of the Civil Procedure Rules. Under that provision, the court is empowered at any stage of a suit to inspect any property or thing concerning which any question may arise. As far as this court is concerned, the purpose of a visit of the locus in court is to enable witnesses clarify what they have already stated in court. When a court visits a locus in court, it goes to check on the evidence already given in court and not to fill up in gaps. If a trial court has to fill in gaps, it runs the risk of being a witness in a case. The view this court takes is that the applicants did not lay sufficient and satisfactory basis for a site visit. Apart from the cost implication, the same would be time-consuming, yet the issues for determination herein can be so determined without such a visit. Accordingly, the prayer for a site visit is hereby declined. Issues number 7 and 8. Whether the lease of the assets of Mumias to Sarai Group should be revoked and Rao removed as both administrator of Mumias as a receiver thereof. These issues are intertwined in view of the allegations and all the grounds raised in support thereof. All the applications sought that the lease be revoked and Rao be removed from the administration and receivership of Mumias. The applicant's case was that Rao was managing the affairs of Mumias in a manner detrimental to all the creditors, that he lacked transparency, was in breach of court orders and statutory provisions, that his decision to award the lease of Mumias assets to the lowest bidder was shrouded in opaqueness, financial unviability, and fraud, that Rao had demonstrated incompetence and conflict of interest. It was contended by the applicants that Rao had breached sections 563, 566, 568, 569, 573, and 570 of the Act, that the decision to leave the assets at the lowest bid detrimentally affects the creditors, especially the unsecured ones, who, given their ranking, their debts may never be repaid. That Rao had interpreted the ruling of 19th of November 2022 selectively with a view to avoid compliance with the statutory requirements. On their part, KCB and Rao denied being guilty of the infractions complained of. They contended that what was in place was an interim administration that was not a full-fledged one governed by the Instruction of the Act, that the administration order only required him to report to court while he continued with his role as receiver manager, that Rao was not bound to consult any other creditor in the leasing of the assets of Mumias, as it was a right that flows directly from the debentures held by KCB. The Act allows challenge to the conduct of an administrator. Section 591(1) of the Act provides for quote, 1. A creditor or member of a company under administration may apply to the court claiming A, that the administrator is acting or has acted so as to detrimentally affect the interests of the applicant, or B, that the administrator proposes to act in a way that would detrimentally affect the interests of the applicant. Subsection 2, a creditor or a member of a company under administration may apply to the court on the ground that the administrator is not performing the administrator's functions as quickly or as efficiently as it is reasonably practicable. Quote. On the other hand, Section 591(4) of the Act provides that the court may A, regulate the administrator's performance or exercise of the administrator's functions or powers, or require him B, to do or not to do a specified act, or require a creditor's meeting to be held for a particular purpose, or end the appointment of an administrator, or generally make provisions of a consequential nature. Further, Section 604 of the Act provides the court may, by order, remove an administrator from the office if satisfied that circumstances exist that make it inappropriate for the administrator to continue in office. From the foregoing, there is power to remove an administrator. It is a power that is discretionary and may only be exercised if there is a good reason or a just cause to do so. This depends on the circumstances of each case. Further, the burden lies on the applicants to show that the removal of the administrator is necessary. Here, F. Fletcher, in the Law of Insolvency, for the edition of paragraph 16-038, page 539, states, quote, such an act of removal is dependent on there being evidence to place before the court, such as will satisfy that there is good cause for removal of the administrator. Possible grounds for such an application might be either real or apparent conflict of interest, or some possibility of bias on the part of the administrator, or some alleged defect in the process of appointment itself. The court will generally require convincing evidence of the matters alleged as reasons for removal of an administrator, or will take into account the wider interests potentially affected by the disruption of the rescue process that was to have been pursued by administration, as well as the consequences of such removal. Quote. In the same text, it is stated at paragraph 14-092 at page 468 regarding a receiver's duty to take reasonable care as follows. Quote, the areas affected by the duty to take reasonable care are sale of the security and management of the mortgagor's business. It is not the decision whether or when to sell which has to be made with the care, but if a mortgagee or receiver sells, care must be taken to secure a proper price. And if a receiver is appointed to manage a business, he must do so with due diligence. A failure to obtain a proper price does not in itself give rise to liability. The mortgagor must additionally prove that the mortgagee or receiver failed to take reasonable precautions to secure a proper price. In Richard Lee Davis Limited, in RHTL International Holdings Limited, 2021 SGHC, the High Court in Singapore, when considering whether it could revoke judicial managers equivalent to our administrators' decision of choosing to sell the assets of a company to one party rather than the other, stated that, quote, great leeway ought to be given to judicial managers to exercise their commercial judgment, which should only be impugned upon evidence of exceptional circumstances. It can be safely concluded that, under statute and case law, before interfering with administration, the insolvency court has to consider certain factors which may include, but not limited to, A, that unfair harm would arise if the administrator treated an applicant less favorably than other creditors. In order to be unfair, such applicant has to show that the decision is unjustified by reference to the interests of creditors as a whole, or in achieving the objective of the administration. B, unfair harm is not limited to differential treatment of creditors and could include an administrator's decision to sell an asset at an undervalue, which would cause loss to the creditors. And 3, in a case where there is differential treatment of creditors, the court will consider if the impugned decision is illogical. The question is whether the present application meets the threshold for interfering with the administration of Mumias. That is, by cancelling the lease entered into by Rao and for his removal. There were various statutory infractions that were alleged against Rao. It was alleged that he was in breach as follows. A, he failed to notify the creditors of Mumias of his appointment within 14 days of his appointment, contrary to section 563 of the Act. B, He failed to lodge with the registrar a notice of his appointment within 7 days of his appointment in breach of section 563(4) of the Act. C. He failed to make a statement setting out proposals for achieving the purpose of administration and lodge the same with the registrar and the creditors within 60 days of his appointment in breach of section 566 of the Act. D. He failed to convene an initial or any creditors meeting not later than 70 days of his appointment, contrary to section 568(1), 569(2), and 573(1) of the Act. And E. Having failed to call the initial creditors meeting, he failed to report to court or the registrar the decision made in such meeting contrary to section 572 of the Act. Rao's response was that since his appointment was interim in nature and not substantive, he was not bound by the strict timelines or the provisions of the Act. That his was not stricto sensu, fully fledged administration. That since his appointment as administrator, while at the same time acting as receiver on behalf of KCB, this was a unique sui generis arrangement. The court notes from the record that KCB and Rao appealed against the ruling of 19th November 2021 by the notice of appeal dated 3rd of December 2021. In that notice, they stated inter alia that, quote, quote, take notice that the first and second respondents, being dissatisfied with parts of the ruling of the High Court at Nairobi, delivered on the 19th of November 2021, intend to appeal to the Court of Appeal against such parts of the said decision as A. Finding the administration can run concurrently with the receivership. B. Granting an administration order and ordering that it will run concurrently with the receivership and consequential orders arising therefrom. And F. Finding that the first and second respondents cannot be said to have acted transparently, quote, quote. Then, in answer to the petitioner's amended motion dated the 31st of January 2022, Rao deposed in his reply affidavit sworn on the 22nd of February 2022 as follows. 5. I have been a receiver manager under the previous regulatory regime governing receivership, i.e., under the Repealed Companies Act, Cap 486, for over 25 years. I was the first insolvency practitioner who was licensed under the Insolvency Act of 2015. I have undertaken various administrations under the Act. I have undertaken various administrations and receiverships of more than 50 companies. 6. Insofar as I am aware, this is the first time in Kenya that a receivership and administration are running concurrently. A concurrent receivership and fully fledged administration would pose various uncertainties given the differences and conflicts in the two legal regimes, i.e., the receivership under the Repealed Companies Act and administration under the Insolvency Act 2015, including the following. A. The laws applicable in the two regimes are different and the attendant applicable legal obligations are not in harmony. B. The reporting requirements and the other obligations under the regimes are different. C. There is no guidance in any statute or case law on how the two should run concurrently. And 9. I am advised by the aforesaid Mr. Kashini, and I verily believe it to be true, that given the novelty of concurrent receivership and administration, an interpretation of the ruling, particularly paragraph 134A5, as highlighted above, is that the administration was limited to filing the specific reports and providing various updates on the operations of the company, as specifically set out at paragraph 134B, Roman 1 to Roman 3 of the ruling. This is because of the use of the words for purposes of reporting to this court, quote, quote. The only irresistible conclusion that can be made or drawn from the foregoing is that Rao is an unwilling suitor. He was aggrieved by his appointment as an administrator, yet he was already a receiver. That is why he appealed against that portion of the ruling. He is conflicted as both an administrator as well as receiver. The court made a firm finding in its ruling of 19th of November 2021 that receiverships in this country have been nothing but pieces of death to struggling companies. in those receiverships. Receivers were but hell-bent to line their pockets at the expense of other creditors and the shareholders of such financially distressed companies. On the other hand, the Insolvency Act was enacted to give a kiss of life to financially distressed companies. It introduced the notion of public interest. The objectives set out in Section 522 are the guiding spirit of any administration. That is the route Rao and KCB want to run from. It should be noted the court had found the two to have acted opaquely between September 2019 and October 2021. By the ruling of 19th of November 2021, the court had sought to call them to order. They were aggrieved by that. That won't do. As held in the cases of China and South Sea Bank Limited versus Tan Soon Jin, 1990 AC 1 AC 936, and Medford versus Blake, receivership was never constrained by any duty to consider the interests of the debtor or its creditors. It was a remedy designed to exclusively protect the interests of the security administration and opted to proceed with receivership. It was alleged that he did not deny that he leased the assets of Mumias to the Sarai group as a receiver manager and not as an administrator, or both administrator and manager, receiver manager as directed by the court. Obviously, Rao is seriously conflicted, which conflict is detrimental to the body of creditors. Rao contended that he found himself in a sui generis position, that this was the first time in this country where one was required to combine the duties of an administrator and receiver. That there is no precedent on how one is to act in such a situation. A simple answer to that contention is that receivers must now be told, and plainly so, that it is no longer business as usual. With the current insolvency law, it is business unusual. In this regard, for Mumias, it is business unusual. When the legislature enacted the Insolvency Act 2015, it made it clear what the objectives of the Act are. They are clearly set out in Section 522 of the Act. In this regard, all decisions made by the Insolvency Court as relates a company and administration must align to their said objectives. As a child is to a family court, so is a company and administration to the Insolvency Court. Every decision must be made in the best interest of that company. That duty extends to and binds an administrator of a company and administration. See the cases of Surya Holdings and Realvind, as well as Medford and Blake, wherein the principle that a receiver manager owes a duty to quote the law and the other creditors was upheld. In this regard, an administrator must at all times align his decisions and actions with the best interest of the company. His duty and loyalty goes beyond the debenture holder who appoints him as such or such receiver. He must undertake his role in a manner that promotes the company as a going concern, where possible, to enable it to repay off its debts and be discharged from administration and receivership. That brings the court to the issue of the lease entered between Rao on behalf of the company and the Sarai group. There were various allegations that were raised against the transaction. That transaction started way back before June 2021 and was strenuously opposed by the creditors. Indeed, one of the applications that was determined in the ruling of 19th of November 2021 was one dated 28th of June 2021 by the petitioner, which sought to restrain the said transaction. This court believed Rao when he stated that the only process to revive Mumias was through the leasing of its assets, getting a strategic partner who was willing to pump in enough capital to operationalize Mumias. The court is aware that Okwani J did in a ruling delivered on the 31st of August 2021 in HCC number E6697 of 2021, the former farmers, and petition number 004 of 2021, Ombata case, direct Rao to undertake the said process in a transparent and accountable manner. This was repeated by the Senate of the Republic of Kenya and this court in its ruling of 19th of November 2021. The question that begs is, was the transaction in accordance with those directives? Was the resultant lease in the best interest of Mumias and the entire body of creditors? It was contended that the process was not only shrouded in secrecy but was defective. The bid documents did not indicate or disclose important information, including a scoring criteria for the technical and financial bids, a reserve price below which the bids would become unresponsive, the debt portfolio of all secured lenders, the revenue that Mumias was generating at its lowest and optimum operations, above all, the value of the assets of Mumias, which were the subject of the lease. On the other hand, Rao and KCB contended that the issue of cancellation of the lease should not be entertained and that it ought to abide the outcome in Nairobi HCC number 004 of 2022. That there was a danger in courts of concurrent jurisdiction arriving at a conflicting outcome. That if it was this court's intention for a creditors committee to be formed to participate in the leasing process, it would have said so in its ruling of 19th of November 2022. A simple answer to Rao's contentions is that Nairobi HCC number 004 of 2021 was a non-starter. The court has already struck out that suit. There is no danger of different conclusions. In its ruling of 19th of November 2021, the court could not direct Rao what to do. It expected him to act as a professional insolvency practitioner who would undertake his duties strictly in accordance with the statutory provisions regarding administration. This he failed to do. This court has considered the allegations raised against the leasing process. They were largely true. Rao awarded the lease to the lowest bidder, while there were higher bidders without any justifiable explanation. He explained that his rejection of the bid for Kenya shillings 36 billion was to avoid monopoly, that bidder was a competitor of Mumias, that it had no financial capability to execute the lease, and that it was a spoiler bid. While this court is aware that it directed Rao to proceed with the leasing process in strict compliance with the Competition Act, it did not expect him to undertake the duties of the Competition Authority of Kenya. There is no evidence to show that he sought any advice on the same before he made the decision that the highest bidder was or would be a monopoly. Further, even if the highest bidder was disqualified for any of the reasons advanced by Rao, there was no explanation why all the other bids that were higher than that of Sarai Group were disqualified. When challenged, Rao did not explain how Mumias would pay off its debts to KCB and other creditors relying on that lease. Probably, this is where a creditors meeting would have been of importance, as Rao's proposal would have been subjected to professional discussion. The unfeasibility of the lease would have been obvious to Rao from the very beginning had he had a meeting with the creditors and proposed the leasing of Mumias assets as he did. It would have been essential to even have a pre-evaluation of Mumias, which would have informed a reserve price for the bids, one that would have achieved the purpose of paying off Mumias debts and release it from receivership and administration. The manner in which Rao handled the leasing process did not tally with what was expected of him as an administrator. This court is inclined to agree with the petition and the other creditors that Rao hurriedly acted in his capacity as KCB's receiver. His action was only meant to protect the interests of KCB, and if the lease is upheld, the same would be tantamount to blessing KCB with an extra asset known as Mumias for the next 20 years. That, of course, would be the greatest miscarriage of justice in the history of insolvency in our jurisdiction. It is this court's opinion that the lease is not in line with the best interests of the company as per the act. It is even more unfortunate that Rao did not produce the lease in court to enable the court to make a more informed decision as to its terms and conclude whether it would benefit Mumias as a going concern or not. The same was withheld from the court without any explanation. What did it contain that Rao did not want to deceive? That remains a speculation. A simple calculation would show that listing Mumias at Kenya shillings 5.8 billion for 20 years, Mumias would perpetually remain under receivership and administration. It would permanently remain an asset under KCB and may be a retirement home for Rao. The latter would superintend administration and receivership for 20 years and yet not be able to repay a single creditor. That won't do. The above circumstances justify this court to interfere with the administration. It is trite that the threshold for interference is a high one, and an administrator is generally given a wide measure of latitude when exercising his duties and powers. The courts will only intervene in circumstances where an administrator is proposing to take a course of action which is based on either the wrong appreciation of the law or is conspicuously unfair to a particular creditor or creditors of the company. The lease in this case meets the standard of unfair harm. It only favors KCB and unfairly prejudices other creditors. At best, It is an undervalued entered into without previous valuation or expert consultation on market value, and under no circumstances can the lease purport to be in the best interest of Mumias as a going concern. It will only bind Mumias in a never-ending receivership and administration, which at the end will not have paid off Mumias' debts. Simply put, the lease does not promote the purpose of Mumias' administration. It is this court's finding that the lease meets the threshold to be interfered with or to be interfered with. In circumstances, the court will interfere with the Rao's administration and cancel the lease. At this juncture, it is important to address the applicant's prayer that the receiver of Mumias be removed altogether. The powers of a receiver manager flow from the debenture under which he or she is appointed. For this reason, courts generally refrain from interfering with the appointment of a receiver unless there are compelling reasons to do so. In LTI Kisi Safari Inc. Limited versus DEG, the Court of Appeal stated, quote, the court can only interfere with a validly appointed receivership if, among other things, it is proved that the conduct of receivers and managers was seriously oppressive or not in accordance with the recognized principles of rule and of commercial practice, or where there are clear and compelling reasons to do so. See also the case of the Court of Appeal decision in Hastings Irrigation Kenya Limited versus Standard Chartered Bank. In the present case, the conduct of KCB and its appointed receiver is pertinent. The record shows that the loans of KCB became unperforming way back in 2017. KCB never took any action or step to either realize its security or recover its outcome. It waited until after this insolvency proceedings were instituted 2 years later in March 2019 to wake up from its slumber. It still waited for yet another 6 months before it appointed Rao in September 2019 as receiver manager. After appointing Rao as receiver in September 2019, receivership continued between them to date. According to the receivership accounts filed in court, the receiver had collected in excess of 800 million between September 2019 and September 2021, when the administration order was made. Out of that amount, not a single cent was ever applied towards repayment of the debt. Rao stated that there was no surplus for such debt repayment. However, the receivership accounts themselves disclosed that while there were no monies to be paid for repayment of debt, there were monies available to pay donations, facilitation, PR exercise, amongst others. KCB was all happy with that state of affairs and advanced Rao yet another handsome amount of Kenya shillings 200 million for alleged operations and continued charging interest on the same. Apart from that, KCB was all impressed with the lease, which was at a grossly undervalued, and folded its hands to continue sitting on Mumias for another 20 years. All the foregoing is but evidence of an uncaring lender who alleges to have been financing Mumias ever since 1974 and would be happy to continue doing so. One other thing, the court is unclear as to how all the alleged debts of Mumias stand by the secured lenders, how they arose, and their status as of now. The court was alive in its ruling of 19th November 2021 that it may be possible that some of the lenders may be out to defeat the indiculum rule. That is why it directed the ascertainment of the due dates when the loans became unperforming. If the management of Mumias is left in the hands of the secured creditors, it is doubtful if Mumias will ever survive. Public interest surpasses all the narrow egocentric interests of the creditors of Mumias. Public interest commands that Mumias survives and is rescued, that its machinery and equipment should roll back to life, that smoke should start billowing from the chimneys of its machinery, that the farmers who are owed millions get paid their dues, and those who would want to plant sugarcane for their future survival do so, that the young unemployed men roaming in the villages of Western Province get jobs to do, that the small businesses who are hitherto in the supply chain of Mumias get a lease of life, that the exchequer gets revenue from the operations of Mumias, etc., etc. That the receivership that has been enforced and that has yielded zero results takes a backseat, at least for a while, and give professional administration of Mumias a chance to be undertaken. the independent administrator to undertake all the options available in consultation with the body of creditors, the secured creditors included, and turn around Mumias. For the avoidance of doubt, the administration order made on the 19th of November 2021 applies to all the assets of Mumias and should be dealt with as such, with a view to obtaining maximum benefit. Accordingly, the court determines all the said applications and makes the following orders. 1. The application dated the 3rd of January 2022 is successful as follows. The appointment of Havin Kadoke as receiver manager of the plants of Mumias is hereby revoked. 2. An injunction is issued prohibiting Victoria Commercial Bank, Ecobank Kenya Limited, and Propaco, their agents, representatives, or assigns from appointing Mr. Kadoke or any other person as receiver manager over the assets of Mumias and from dealing in any manner whatsoever with the plants during the pendency of the receivership and or the administration. 3. Any disposition, transfer, assignment, letting, leasing, or any other dealing in the company's plants by Victoria Commercial Bank, Ecobank Kenya Limited, and Propaco or their assigns is hereby declared to be void. B. The application dated 31st January 2022 is dismissed save for the prayer seeking an order to nullify the lease of the company to Sarai Group, which is hereby granted. Accordingly, the lease made to Sarai Group on the 22nd of December 2021 or thereabouts is hereby revoked, cancelled, and nullified, and Sarai Group ordered to forthwith vacate the premises of Mumias. C. The 5 former employees' application dated the 10th of February 2022 is hereby dismissed. D. The application dated 10th of February 2022 by Dr. Hamino and Hamino Advocates and Wekesa Simiyu Advocates partially succeeds. The creditors committee shall be established at the initial creditors meeting to be held at the appropriate time and in accordance with the law, and as shall be directed by the administrator. E. The application dated the 4th of March 2022 and the preliminary objection of 7th March 2022 are dismissed. F. The application dated 28th January 2022 partly succeeds and the applicant therein, Vartox Resources Inc., is joined in this suit as a party to prove its claim, if any. G. Mr. Ponangipali Ramana Rao is hereby removed forthwith from the administration of Mumias Sugar Company Limited. H. From the list obtained by the Deputy Registrar of this court from the official receiver in insolvency, the court hereby appoints Kereto Marima of KR Consult Limited to be the administrator of Mumias Company Limited forthwith. I. Mr. Ponangipali Ramana Rao to formally and in an orderly manner hand over to Kereto Marima the full and unhindered control and administration of Mumias within 7 days of the date hereof. J. Mr. Ponangipali Ramana Rao as receiver manager appointed by KCB to cooperate with Kereto Marima and ensure the smooth administration of Mumias. In default, the receivership shall stand suspended during the duration of the administration. Okay. The new administrator to call for and ascertain the claims of the unsecured creditors within 60 days of the date hereof, the dates they became unperforming, and the amounts outstanding as of those dates, and lodge the same with the court accordingly. And finally, due to the heavy public interest element involved in this matter, each party shall bear costs. Those are the orders.
Your Lordship, just one short point.
Yes.
In light of the orders, I don't believe there's an automatic right of appeal under the Insolvency Act. Perhaps for good order's sake, you would grant the first and second respondents leave to appeal against such parts of the order as affected.
If leave is needed to appeal to the Court of Appeal, the same is hereby granted.
Much obliged.